to AIBE 21st exam. This is one more full-length model paper. It has 100 MCQs, multiple choice questions, just as in the exam, and it covers all 19 subjects as specified in the exam syllabus, and 100% of the questions are marked with correct choices as well as a brief explanation about why that choice is the correct choice. So this is solved with detailed legal reasoning, updated to current law, BNS, BNSS, and Sakshya Adhiniyam as well. So please review this leisurely at your own pace. And if the audio is too fast or too slow, you can mute the audio and then go through the video part at the speed you need. And I'm sure this will be of great help in the upcoming examination of AIBE. With that, let's go to the next idea, where the complete syllabus and how many questions are expected from each subject area as per the syllabus is laid out here. The syllabus talks about 19 subject areas, and overall we will have 100 questions from these areas. However, some areas have more weightage than the other areas. So the subject areas like constitutional law, criminal procedure, civil procedure, and they are expected to have 10 questions from each subject area. And and you can read it and be familiar with this. And some of you may want to start with the areas where more number of questions are expected, and maybe there are some areas which are more comfortable for you. So whatever way it is, you plan accordingly and try to identify the bare acts with every question, and within the bare act, how to navigate to the chapter, section, or the particular definition that we are looking for. With that, let's move on to the first question. This question, if you look at this template, on the top left corner, the question number is identified, which is not very important, just the serial number. And on the top, you'll see an area where the subject area is listed. For example, this question is taken from constitutional law. Totally 10 questions are expected from constitutional area. So whenever you come across a question, and they need not be in a cluster, as a cluster, and the questions from the 10 questions from constitutional area are randomly distributed throughout the question paper. So it's only to give you a hint that this question is from constitutional law. Then you'll see the text of the question, the stem of the question, just the question. Try to understand it, slowly read it, and see if it makes any sense to you, and if you think you have a way to approach this question to solve it. Followed by 4 choices, A, B, C, D. That is how the latest exams are naming the choices. And here, so that we can move faster, instead of spending 3 hours on the exam, just like in the real exam, uh, for the preparation's sake, so that everybody has to move forward at a faster pace, we have presented all 4 choices. At the same time, the correct choice is also highlighted in green with a check mark, the tick. And then there is a bottom grid, an area where explanation is given. This explanation is important in the sense what really happened in our judiciary or in our legislature, and what led to this concept legally defined or legally finalized the way it is. So this will give us some idea about how to approach this problem and where to look for this particular the correct choice or the correct answer, the correct definition. So let us see how to go about it. The fundamental duties, not the rights. Duties is the word that we need to catch. So fundamental duties of citizens were added to the Constitution by which amendment? That means the Constitution, which was originally authored and adopted in 1950, did not have fundamental duties. So they were later on added to the Constitution. Having identified that, and we need to identify the amendment in which the fundamental duties were added. So the choices given here are 44th Amendment, 42nd Amendment, 73rd Amendment, 86th Amendment. See, all these amendments are important in their own right, and they stand for something very important, amendments to the Constitution. However, we'll go through these things. In fact, you should be looking at 73rd Amendment is for what? 86th Amendment, what was the achievement? 44th Amendment, what did we do? That is one way to dig into the Constitution or remember the major changes or the major achievements we made through amendments. So here, 42nd Amendment. What is the story behind 42nd Amendment? In 1976, the 42nd Amendment to the Constitution was made, and in that they have inserted Part 4A. See, obviously, a Roman number or other Arabic number followed by A, B, something like that, that indicates that this is from an amendment, which this was not originally available in the original Constitution adopted in 1950. In that, Article 51A, fundamental duties were inserted. So, the idea is amendment is 42nd Amendment, which happened in 1976. In that amendment, they have inserted a part 4A, fourth part, 4th A, and then Article 51 was also inserted, and it was fundamental. It was for fundamental duties. Then, just as a side note, what happened in 86th Amendment? 86th Amendment added education and as a fundamental right. So similarly, 44th and 73rd also. 73rd was related to transfer of uh, responsibilities, rights and responsibilities to the panchayats. So things like that. As we go along, we should be able to identify the major achievements of these amendments. I think with that type of analysis, if you spend some time on this question and the choices are also very important choices because they're not random, they're all important. We know and we studied about these things, but in this context, when we talk about fundamental duties, when was that idea inserted into the Constitution and in which part, which article, etc.? B is the correct choice. Moving on, under BNSS, obviously, once the act is identified, we know that this is from that act. Under BNSS 2023, forensic investigation is mandatory for offenses punishable with. What type of offenses call for forensic investigation? Or forensic investigation is made mandatory for this class of offenses. What is that class of offenses? In which uh, one could be punished for up to 7 years or more. So if the offense is so grave, where the punishment calls for 7 years or more, of imprisonment, then such offenses should be forensically investigated also. That's the idea which was inserted in BNSS 2023. So the explanation is Bharatiya Nagarik Suraksha Sanhita BNSS, which was adopted in 2023, makes forensic investigation mandatory for offenses punishable with 7 years or more of imprisonment. So that's how we need to correlate them. We need to understand. So this is a question from the third subject area of our syllabus, criminal procedure, CRPC, which was the old code, and its replacement is BNSS, Bharatiya Nagarika Suraksha Samit, Nagarik Suraksha Samit, Sanita. Moving on to the next question. This is taken from the fourth subject area, Civil Procedure Code, Code of Civil Procedure, CPC, in which the procedure also is discussed, right? Is discussed. Under Order 1, the first order, Rule 8 of CPC, a representative suit can be filed where? Where can you file a representative suit? D is the answer. Numerous persons have the same interest in one suit. So, if the people who are interested in filing the suit is in great numbers, not everybody need to file the suit, but they all can come together and they can file suit, which is known as representative suit. Order 1, the first order, Rule 8 of CPC, lets one sue or defend for numerous persons with the same interest. So D is the correct choice. Now, moving on to question number 4. This question is taken from criminal law, IPC, Indian Penal Code, which was replaced by Bharatiya Nyaya Sanhita. This is a substantive law in which, of course, this area is taken as the second subject area number 2 for AIBE as per the syllabus. This question is taken from that area. Under the Bharatiya Nyaya Sanhita BNS 2023, theft is defined under which section? Section 303, which is a direct answer. So how do we know? We should be familiar with BNSS because we can take the Bare Act BNSS. No, if it is defined for the meaning, then definitions section will tell us. If it is defined under some section, here they are interested in sections, then obviously we need to look into the index, chapter wise index, and then somewhere we come across theft, robbery, and all these things probably are together somewhere. If you are familiar with BNS, the Bare Act, and if you look for theft, once you look for theft before going into the exam, you will know how to look for such offenses. And this offense is defined under section 303. It defines theft and its punishment, which corresponds to section 378, 379 of IPC. So now we moved on to BNS. So for all the new crimes, since the adoption of the new criminal laws, new FIRs will be filed under these acts only, not the old numbers. However, for reference sake, we will remember that 379 of IPC, 378 or 379 of IPC defined theft, and now 303 of BNS does the same. And similarly, what about section 318, 356, 379? Okay, just because we are here, maybe you want to take a look at them also, so that you can, in your mind, you can map and start remembering some sections which come time and again, which are more frequently uh, invoked. The next question comes from the subject area, evidence. Of course, the old act was Indian Evidence Act, and the corresponding new act is Bharatiya Sakshya Adhiniyam. The question is on evidences. So, under Bharatiya Sakshya Adhiniyam 2023, communications during marriage between spouses are, so husband and wife are spouses, as long as their marriage, as long as they are married, and the communications between them, what what about those communications? See, if in case of dispute between them or for some other reasons, can you take those communications and do something with that in the code of law? Choice A says they're always admissible. No, not necessarily. They're always inadmissible in all proceedings. That's also not true. Then what? These communications are generally protected as privileged communications with some exceptions. So we should look for exceptions, but generally they are protected because it's like communication between an advocate and his client, communication between a patient and a doctor. So there is some protection. They're generally protected under unusual circumstances with the court's permission. If there are valid exceptions, then only they will be admitted as part of some proceedings. Uh, and then D says admissible only in civil suits. Civil or criminal, it doesn't matter. If they can be admitted or not, if they are protected or not, that's what we are more concerned about. Yes, as long as spouses are married, the marriage is on, the communication between spouses are generally protected, period. And of course, with some exceptions, that exceptions call for guidance from the court also. BSA protects spousal communications during marriage as privileged. In Indian Evidence Act, Section 122 did the same too. Now, moving on, this question is taken from family law. Under the Special Marriage Act 1954, a marriage can be solemnized between persons irrespective of their religious background, their religious beliefs, their faith system. So, if two Hindus want to get married, they get married under Hindu Marriage Act, as per the Hindu Marriage Act. If two Muslims get married, they want to get married, they may get married under Muslim law. Whereas, if you are not very particular and if you are not of any particular faith, then you can be you can get your marriage done under Special Marriage Act 1954. So the Special Marriage Act 1954 allows civil marriage between any two persons of any religion. B is the correct choice. Moving on, this question is taken from Indian Contract Act. Of course, for our exam purpose, and from our syllabus, if you see in our syllabus, if you look at it, subject area 17, which consists of multiple acts like Indian Contract Act, Property Transfer Act, Transfer of Property Act, Non-Negotiable, Negotiable Instruments Act, Negotiable Instrument Act. These are primarily three acts that are covered under the 17th subject area. So the questions can be from any one of these acts, of course. Under the Indian Contract Act 1872, a contingent contract dependent on an impossible event is void. Under Section 36, a contingent contract dependent on an impossible event is void. So we should not get into any contract. Two persons cannot get into any contract which depends on an impossible or illegal event. So automatically such contracts are void. So impossible, and also we can say if that whatever is expected to be done because of that contract, if that happens to be illegal, then also the contract is void. This question is taken from the subject area tort, Motor Vehicles Act, Consumer Protection. All those acts are covered under subject area 15 in our syllabus. So that's why those different names are showing up as part of the subject line. So the rule in Rylance versus Fletcher imposes liability that is strict. No fault need to be proved. Strict liability means no fault need to be proved. The affected person, the victim, can always claim for some compensation. Rylance versus Fletcher, which defined the doctrine of strict liability for escape of a dangerous thing irrespective of fault. So choice D is the right choice. Once we are here, obviously, what are the other doctrines related to this concept? The absolute liability. In which case it was decided, the doctrine was propounded, and if you explore the related concepts while you are here, I think that will also help. The absolute liability is the other concept, and you can look it up. Which case, which pill, what year, those things are propounded. Moving on to the next question. Under the Arbitration Act 1996, interior measures by a court may be sought under Section 9 of the Arbitration Act. So the arbitration, conciliation, mediation, all these things are dealt with under alternate dispute redressal ideas. Arbitration, conciliation, and mediation. Arbitration Act deals with these things, and Section 9 of that Act allows you to seek interim measures. Section 9 allows a court to grant interim measures before or during arbitration. Next question. By which public interest litigation did the Supreme Court lay down guidelines against workplace sexual harassment? In Vishaka versus State of Rajasthan. In that case, the Supreme Court laid down binding guidelines against workplace harassment. Well, because it was done in Supreme Court, the way this bill was allowed was under Article 32. Article 32 allows public interest litigations to be filed under in Supreme Court. So Supreme Court dealt with this case, and they laid down binding guidelines against workplace harassment, especially harassment of women. Clear guidelines were laid down. So this was Vishaka versus State of Rajasthan. A is the right choice. So this falls under the subject area 8th, item 8, which deals with public interest litigation. Now, the next question is from professional ethics. When we talk about professional ethics, we are mostly concerned about bar advocates who are governed by the Bar Council of India and its rules. Uh, so the question is, under the Bar Council of India rules, the cab rank principle requires that an advocate ordinarily, under normal circumstances, should not refuse a brief due to the client's unpopularity. So just because the client is unpopular, maybe the suspect in a case may be right, may be wrong, or maybe the subject area itself is not generally seen with in good light. Whatever may be the reasons, maybe you're not happy with the subject at hand, or maybe you're not happy about the client that you are you that came to seek your assistance. No matter what, an advocate cannot refuse to take it up. This is known as cab rank rule. An advocate should not refuse a brief for the client's or causes unpopularity. D is the right choice. The next question is, the wide interpretation of term industry under the Industrial Disputes Act 1947 was given in Bangalore Water Supply and Sewage Board versus A. Rajappa. Bangalore Water Supply in 1978 gave the wide triple test for industry under the Industrial Disputes Act. C is the right choice. This question is taken from labor and industrial law areas, 14th area from our syllabus. The GST Council, the constitutional body that makes recommendations on GST, is constituted under Article 279A. So things related to GST, they were all considered and approved, and they were made part of the Constitution through 101st Amendment. So in this amendment, Article 279A and also other sections were added or modified. Section 279A sets up the GST Council to recommend GST rates and matters. A is the correct choice. The principle nemo judex in causa sua is a facet of. What is this part of? That's the idea. First of all, this Latin maxim means, we should understand what it means. It means no person can be a judge in his own case. Okay? This is to protect natural justice. This is to honor natural justice, and this will avoid bias. So, if the judge has something to do with the persons in dispute, or if the judge has some direct or indirect benefit related to this particular dispute, then the judge should not be party to the case, and that is how they excuse themselves and they claim not before me, just to safeguard the natural justice, the ideas of natural justice. Nemo judex in causa sua is the rule against bias, a facet of natural justice. So, natural justice has two primary conditions. One, you should always hear the other side. Two, no person can be a judge in his own cause or case. The principle that a company is separate legal person was formally established in Solomon versus Solomon and Company Limited. Solomon versus Solomon and Company in 1897, um, they were seen as separate legal personalities in this judgment. The court decided that a person is different from the company. The person is responsible for starting up, maybe establishing, unless and until there is some sort of uh, cheating, and the company is established only for the to facilitate cheating, then that individual is also becomes responsible. Otherwise, a company which is incorporated is seen as a different person compared to the person who actually established the company. C is the right choice. Now, this question is from environmental law. The public trust doctrine that the state holds natural resources in trust was applied in MC Mehta versus Kamal Nath. The public trust doctrine to natural resources was applied in MC Mehta versus Kamal Nath in 1997. Under the IT Act 2000, tampering with computer source documents is an offense under Section 65. It penalizes tampering with computer source documents and documents required by law. So, C is the correct choice, Section 65. This question is taken from the area of land acquisition. Under the Land Acquisition Act 2013, a key safeguard before acquisition is a social impact assessment. The 2013 Act mandates a social impact assessment and consent before land acquisition. If the government proposes to acquire land for the ultimate use of a private entity for its use, maybe in setting up a company or maybe to do something which is ultimately useful for the public. However, if the land acquisition is done for the sake of a private entity, at least 80% of those who are going to be impacted should give their assent to that proposal. That's what we call social impact assessment. If the land is acquired for a public-private partnership project, then only 70% of the 70% of those affected should give their assent. So this is the 80-70 rule. For private parties, the social impact assessment at least 80% of the 80% of the owners or those who are affected should give their assent to such an acquisition. In case of public-private property projects, 70%, if 70% give their assent, then the acquisition proposal can go ahead. Under the Trademarks Act 1999, the initial term of trademark registration is. This question is from Intellectual Property Law 19 of our syllabus. Okay. Under the Trademarks Act 1999, the initial term of trademark registration is for 10 years, and subsequently it can be renewed. A trademark registration lasts 10 years, and its renewal for further 10-year terms as per Section 25 of the Trademarks Act. So, initially for 10 years, then after renewals for every 10 years. This question once again is from constitutional law. The preamble to the Constitution was held to be a part of the Constitution and amendable in Keshavananda Bharati case. Keshavananda Bharati versus State of Kerala. Keshavananda Bharati, 1973. The preamble is part of the Constitution, amendable under Article 368. However, the basic nature of the Constitution cannot be amended. Under BNSS 2023, maximum detention before charge sheet for offences of 10 years or more is 90 days. Default bail accrues if investigation is not done in 90 days in 10 years or plus offences. Else, 60 days is the limit. Under Section 9 of CPC, civil courts have jurisdiction to try all suits of a civil nature except those expressly or impliedly barred. Generally, all civil matters can be taken up by the civil courts unless and until they are expressly or impliedly barred by the superior court or by the statute. Section 9 CPC. Civil courts try all civil suits except those expressly or impliedly barred. Next question. This is taken from criminal law. Under BNS 2023, mob lynching by a group of 5 or more is punishable with. A group of 5 or more is considered a mob. Mob lynching, meaning killing somebody as a group. You go in a group, you go as a group, you plan as a group, and you kill somebody, you lynch somebody. In such cases, the punishment is death or life imprisonment and fine too. BNS punishes mob lynching by 5 or more people on grounds like caste with death or life and fine. So the punishment is either death penalty or life imprisonment and fine. A dying declaration is admissible under the BSA 2023 primarily because declarant is presumed to speak truth at the point of death. Dying declaration, section 26 of BSA, is admissible as one near death is presumed not to lie. Under the Hindu Marriage Act 1955, the minimum age for valid marriage is 18 years for brides and 21 years for grooms. Hindu Marriage Act section 5(3), the minimum marriage age is 21 years for the groom and 18 years for the bride. Next question. An agreement without consideration is void under the Indian Contract Act 1872, except, what are the exceptions to this generally agreed principle? If the agreement is made for natural love and affection, if the agreement is made in written and registered uh, for the services rendered as a payment, or some other some other situations where there is no real consideration required. So in all other cases, agreements or contracts without consideration are void. Section 25 says an agreement from natural love and affection in writing and registered is valid, though there is no consideration. Next question. It's on TOTS. The TOT, Motor Vehicle Consumer Protection, all subject area 15 of our syllabus. Under the Consumer Protection Act 2019, the District Commission's jurisdiction limit is 50 lakh rupees. Under the Arbitration Act 1996, the number of arbitrators in a tribunal must not be an even number. Section 10 says the number of arbitrators must not be even, failing which a sole arbitrator acts. Public interest litigation. In public interest litigation, the procedure where a court treats a letter or postcard as a writ petition is known as epistolary jurisdiction. Epistolary jurisdiction lets a court treat a letter or postcard as a writ petition in public interest litigation. Next question. Professional ethics. In VC Rangadurai versus D. Gopalan, the advocate-client relationship was held to be fiduciary, demanding at most good faith. The advocate-client relationship is fiduciary, demanding at most good faith. Under the Industrial Disputes Act 1947, retrenchment does not include termination of service by way of disciplinary action. Section 200 of Industrial Disputes Act, retrenchment excludes termination by way of disciplinary action because retrenchment calls for compensation. So you cannot, just because you have to pay some sort of compensation, you cannot call or you cannot terminate people as a punishment unless there is a reason, there is a laid down a reason for disciplinary action which led to termination. All other terminations are not treated as disciplinary. So retrenchment procedures guidelines must be followed. Under the Income Tax Act 1961, income is taxed in the previous year and assessed in the assessment year. The year following the previous year is the assessment year. If this financial year is the assessment year, the financial year preceding this year is the previous year. Income of the previous year is taxed in the following year, which is also known as assessment year. Sections 2 and 3. The doctrine that an administrative authority must not exceed the powers conferred by statute is you cannot exceed the powers conferred by statute. It's called the doctrine of ultra vires. Ultra vires deals with acts beyond statutory powers and call them invalid and make them invalid. The basis of judicial review. Under the Companies Act 2013, the minimum number of members required to form a private company is 2. A private company needs a minimum of 2 members as per section 3, while a public company needs 7 members at least to start with. This question is from environmental law. The polluter pays, and precautionary principles were firmly recognized in Indian law in Vellore Citizens Welfare Forum versus Union of India. Under the IT Act 2000, identity theft using another's unique ID is an offense under Section 66. So if you use somebody else's password, somebody else's fingerprint, somebody else's retina, iris of the eye, or any other personalized confidential uh, things to gain access to computer systems is an offense as per Section 66C. The state's power to acquire private property for a public purpose rests on the doctrine of eminent domain. Eminent domains is the state's inherent power to acquire private property for a public purpose. Under the Copyright Act 1957, copyright in a literary work lasts the author's lifespan plus 60 years. So, here, one thing we need to remember, copyright has its own act, whereas trademarks, that type of things are in separate. It's a separate act. So, trademarks, logos, marks, that type of things are protected in one fashion, whereas copyright is protected entirely in a different manner. This is author's lifetime plus 60 years after his death. The right to education as a fundamental right is enshrined under which article? Article 21A. Article 21A, the 86th Amendment, makes free and compulsory education a right for ages 6 to 14. 6 to 14. Under BNSS 2023, anticipatory bail is dealt with under which section? Section 482 of BNSS provides for anticipatory bail, which corresponds to 438 of CRPC. Amendment of pleadings under CPC is governed by Order 6th, Rule 17. Under the Bharatiya Nyaya Sanhita 2023, community service as a form of punishment for community service is recognized as a form of punishment. Bharatiya Nyaya Sanhita Section 4 introduces community service as a punishment for certain petty offenses. Simple, small, not that grave offenses. Evidence. Indian Evidence Act, which is replaced by Bharatiya Sakshya Adhiniyam. This is the question. This is one question from this area, from the area of evidence. Leading questions under the Bharatiya Sakshya Adhiniyam 2023 may ordinarily be asked in cross-examination. Leading questions may be asked in cross-examination, not in chief or re-exam if objected to. Under the Hindu Marriage Act 1955, cruelty as a ground for divorce includes both physical and mental cruelty. Under the Transfer of Property Act 1882, a mortgage is defined as the transfer of Section 58 of Transfer of Property Act says a mortgage transfers an interest in specific immovable property to secure a debt. So C is the right choice. Next question. Under the Consumer Protection Act 2019, a consumer does not include a person who obtains goods for resale or commercial purposes. A consumer excludes one buying goods for resale or commercial purposes. Self-employment exempted. So if you are the only person trying to sell something in retail and you are the sole owner of your business, then you may be considered as a consumer. But otherwise, you are not considered, you are only an intermediary, reseller. Alternate dispute redressal and arbitration. This is the subject area. Under the Arbitration Act 1996, where a matter has an arbitration agreement, the court shall refer the parties to arbitration. Section 8. The right to a speedy trial for under trial prisoners was recognized through a public interest litigation in Husainara Khatun versus State of Bihar in 1979. Next, an advocate's right to practice is regulated and misconduct dealt with primarily under the Advocates Act 1961 and BCI rules. This is from Professional Ethics, subject area 10. The Advocates Act 1961 and BCI rules together govern the right to practice and professional misconduct. Under the Employees Compensation Act 1923, an employer is liable for injury caused by accident arising out of and in the course of employment. B is the right choice. Under the GST regime, the tax levied by the center on interstate supplies is called CGST. Intrastate. Intra meaning within. Intrastate supply attracts CGST. Center and SGST state. Whereas interstate, inter meaning between two states, it attracts IGST. That's the difference between three components, three different acts. The doctrine of legitimate expectation enables judicial review where a public authority departs from settled practice or promise without fair procedure. That means we have an expectation of something to be done by an authority, and if the authority refuses to do the same expected thing, then the legitimate expectation is not honored, dishonored. Special status and temporary provisions for Jammu and Kashmir were originally contained in Article 370, which was effectively abrogated in 2019. Under BNSS 2023, maintenance of wives, children, and parents is now in Section 144 in Bharatiya Nagarik Suraksha Sanhita. Rejection of a plaint is provided under which order and rule of the CPC? Order 7th, Rule 11. Allows rejection of a plaint, for example, no cause of action or suit barred. Under the Bharatiya Nyaya Sanhita 2023, the offense formerly known as sedition has been replaced by an offense on endangering India's sovereignty. BNS drops sedition. Section 152 penalizes acts endangering India's sovereignty, unity, and integrity. Section 152 of the new criminal law, Bharatiya Nyaya Sanhita, replaced the word sedition and it introduced a new clause. A confession made to a police officer is, under Bharatiya Sakshya Adhiniyam 2023, is inadmissible against the accused. BSA bars proof of a confession made to a police officer. Formerly, the same thing was laid down under sections 25 and 26 of Indian Evidence Act. Family law. Restitution of conjugal rights under the Hindu Marriage Act 1955 is provided under Section 9. Section 9 of Hindu Marriage Act allows restitution of conjugal rights, revival of conjugal rights, where a spouse withdraws without reasonable excuse. Then the other spouse can seek for restitution of conjugal rights. Can seek restitution of conjugal rights. Under the Sale of Goods Act 1930, a condition as opposed to a warranty is a stipulation essential to the main purpose. Breach entitles repudiation. C is the correct choice. Next question. In tort law, vicarious liability generally arises in the relationship of master and servant, employer and employee. Vicarious liability arises in master servant. The master answers for the servant's tort at work. The next question is, under the Arbitration Act 1996, an arbitral award can be set aside by a court under Section 34. Section 34 provides exclusive grounds to set aside a domestic arbitral award. The relaxation of locus standi to enforce the rights of the disadvantaged is the basis for public interest litigation. Appeal rests on relaxed locus standi, letting any bona fide person act for the disadvantaged. Under the Bar Council of India rules, an advocate is generally prohibited from advertising or soliciting work. BCI rules bar advocates from advertising or soliciting work. Law is a profession, not a trade. Under the Payment of Wages Act 1936, an employer's deductions from wages must be only those authorized by the Act. The Payment of Wages Act permits only the deductions it specifically authorizes. A is the right choice. Under the Central Goods and Services Tax Act 2017, GST is a tax levied on supply of goods or services or both. Reasonable restrictions on free speech can be imposed under which clause of Article 19(2). Under BNSS 2023, registration of an FIR in cognizable cases is governed by Section 173 of BNSS 2023, which is same as Section 154 of CRPC. The bar on trying a suit already directly and substantially decided in a former suit is res judicata. Section 11 CPC embodies res judicata, barring re-litigation of an already decided issue. Under BNSS 2023, a cheating and including delivery of property is under cheating and inducing delivery of property is under Section 318 of BNS. It's same as Section 420 of IPC. Under the BSA 2023, a fact is said to be proved when the court thinks its existence so probable a prudent man acts on it. A fact is proved when a prudent person would act on its existence and the matters before it. B is the right choice. Under the Dissolution of Muslim Marriage Act 1939, a Muslim wife may seek dissolution if husband's whereabouts are unknown for 4 years, among other things. A contract caused by undue influence is voidable at the option of the party whose consent it caused. Under Section 16 and 19A, a contract caused by unique influence is undue influence is voidable by the aggrieved party. Whoever doesn't like it, whoever is not happy about the contract can seek for dissolution. The maxim res ipsa loquitur in the law of negligence means the thing speaks for itself, presuming negligence, raising a presumption of negligence. The directive principles of state policy are contained in which part of the Constitution? Part 4. They are not enforceable but fundamental in governance. Under the BNSS 2023, a summons may now be served through electronic means as well in the prescribed manner. BNSS expressly allows service of summons by electronic means in the prescribed manner. Execution of a decree is governed primarily by which provisions of the CPC? Sections 36 to 74 and Order 21st. Under the Bharatiya Nyaya Sanhita 2023, the punishment for murder is provided under Section 103. similar to 302 of IPC. Facts forming part of the same transaction, res gestae, are relevant and admissible. Facts forming part of the same transaction, res gestae, are relevant and admissible. Maintenance to a divorced Muslim woman under the 1986 Act per Daniel Latifi must be a fair and reasonable provision made within the iddat period. Daniel Latifi, the husband must make a fair and reasonable provision for a divorced wife. Under the Indian Contract Act 1872, a minor's agreement is void ab initio. Mohori BB. A minor's agreement is void ab initio according to Section 11. Necessaries reimbursable according to Section 68. The 73rd constitutional amendment relates to Panchayati Raj institutions. The 73rd Amendment gave Panchayati Raj constitutional status via Part 9, 11th Schedule. Under BNSS 2023, the HSC sessions power to grant bail in non-bailable offences is in Section 483. Section 483 BNSS gives High Courts, Sessions Courts special bail powers. The CPC provision encouraging settlement via arbitration, mediation, or Lok Adalat is Section 89 of CPC. Lets courts refer disputes to arbitration, conciliation, mediation, or Lok Adalats. C is the right choice. Under BNSS 2023, the general exceptions, accident, private defense, etc., operate to exempt the act from criminal liability. General exceptions, accident, necessity, private defense, etc., make an act not an offense. The best evidence rule requires that the contents of the document be prepared, contents of a document be proved by primary evidence, that is, the original document. Best evidence rule. A document's contents are proved by primary evidence, the original. Under Muslim law, mahar, dower is sum or property payable by husband to wife on marriage. Mahar is money or property the husband must pay the wife as an incident of marriage. Under the Negotiable Instruments Act 1881, dishonor of a check for want of funds is under Section 138. And Section 138 of NI Act makes check dishonor for insufficient funds an offense. Notice required. The doctrine of basic structure of the Constitution was propounded by the Supreme Court in Keshavananda Bharati versus State of Kerala. Keshavananda Bharati, 1973, Parliament may amend but cannot alter the basic structure. Under the Bharatiya Nagarik Suraksha Sanhita 2023, a zero FIR allows a person to register an FIR at any station regardless of jurisdiction. Zero FIR, BNSS, an FIR may be registered at any police station regardless of jurisdiction. An appeal from an original decree, first appeal, lies under which provision of the CPC? Section 96. Section 96 of CPC provides a first appeal from an original decree. Section 100 governs second appeals. Under BNS 2023, private defense of the body may extend to causing death where one apprehends death or grievous hurt. Private defense of the body may extend to causing death where death or grievous hurt is feared. So A is the right choice, death or grievous hurt. From the Evidence Act, an accomplice is, under the Bharatiya Sakshya Adhiniyam 2023, a competent witness whose evidence may require corroboration. An accomplice is a competent witness. Conviction needs no corroboration, but prudence seeks it. From Family Law, under the Hindu Succession Act 1956, an as amended in 2005, a daughter in a coparcenary becomes a coparcener by birth in her own right, like a son. So 2005 amendment, section 6 of Hindu Succession Act, a daughter is coparcener by birth like a son. Vinitha Sharma case. Under the Indian Contract Act 1872, an agreement is restraint of trade. An agreement in restraint of trade is void to the extent subject to exceptions. Void to that extent, comma, subject to exceptions. Section 27. An agreement in restraint of trade is void, except sale of goodwill within limits. The right to privacy as part of Article 21 was affirmed in case Puttaswamy versus Union of India in 2017. Privacy is a fundamental right under Article 21. Under the BNSS 2023, trial of certain proclaimed offenders in their absence, trial in absentia, is expressly provided for proclaimed offenders who abscond. BNSS expressly allows trial in absentia of a proclaimed offender who absconds to evade trial. The pecuniary and territorial competence of a civil court to entertain a suit relates to its jurisdiction. Jurisdiction is equal to a court's authority, pecuniary, territorial, subject matter, to decide a matter. The amendment procedure of the Constitution is provided under which article? Article 368 lays down the procedure to amend the Constitution. Some need state ratification. Under the BNSS 2023, in cases of arrest, the use of handcuffs is permitted for specified offenses, for example, habitual or heinous offenders. Bharatiya Nagarik Suraksha Sanhita allows handcuffs for specified categories like habitual offenders and certain heinous crimes. Finally, a temporary injunction may be granted by a civil court under which provisions of the CPC. Order 39, Rules 1 and 2 of CPC allow temporary injunctions on the usual threefold test. So with that, I think we have come to the end of this model paper. Most of the questions are taken uh, from previous exams, uh, and also as per the syllabus specified for AIBE 21. So make use of these questions, the way they are framed, choices, the selection of choices, how to identify the right choice, how to identify from which subject area, which particular act this question is um, based on, and these details, such details will help you even if you don't know the section, even if we don't know the definition or other details of a particular offense or related matters, an issue at hand. Definitely, we navigate ourselves very easily to the concerned area of the Bare Act, and because this is an open book with the Bare Acts type of exam, definitely having familiarity with the subject, having familiarity with the barracks, having familiarity with the book that you are taking with you, including the chapters, the sections, the index, and how to refer index and table of contents to locate the actual material, the actual content that we are interested in a particular act. With that, I think this is the answer key. Just for record, whatever we have seen so far, let's summarize it in one place. The point to note is, how do we know if the choice is A, B, C, or D? Which one is more prevalent, less prevalent, and can I really guess? Well, given the computing facilities today, most of the exam agencies, they know how to frame the question sets. They know how to frame multiple sets. They know how to jumble, randomize questions, and within a particular question, they also know how to randomize choices. So probably there are different sets, and there is no guarantee that within that set all the choices under a question are exactly positioned the same way. So it's very difficult to guess. Of course, if we don't know the answer, we have to guess. But the way we make that guess, if it is an educated guess, the chances of that getting and the probability of that educated guess becoming the right choice is relatively higher. So that as a consolation, if you don't know how to look it up in the Bare Act, if you think you are going to miss out or there is not enough time left, so at the end, uh, choose whatever letter you want or whatever you think is the right choice, but do something, do choose a choice and complete the answer sheet. You complete 100% of the questions because there is no negative marking for wrong answers. Study smart, but you need to practice. Practice only makes this type of exams easy, and we can go through the bare ranks, front to back, back to front, read about the sections. Not every word of that section, but at least we should have a vague idea of okay, these are the topics covered under this act, by this act. And if somebody asks me about this topic, I know it is from CPC, I know this is from BNS, I know this is from IPA, IPC. So you need to figure out from which subject area, which act this question is. And that much familiarity definitely helps minimize the time to look it up, should you need to look it up in the Bare Act. Thank you once again. If you think the material has been useful in your preparation, please like this video and share it to your friends. The more people get to know about it, the more people start practicing using this material. I think we can also put more effort in making them much more robust. Uh, that helps. The more people watching these videos definitely helps us. You please do subscribe to this channel, because this channel is slowly but surely evolving into an educational hub, dealing with major educational branches like law, sciences and technologies, space technologies. Definitely, that is one area we are interested in. And the IT related, the computer sciences related technologies like data sciences, machine learning, and artificial intelligence. Those three are definitely evolving into artificial intelligence engineering. So we want to put more and more efforts, more and more material in those areas also. So for you, your friends, for you in your profession, I think artificial intelligence is essential. So I hope you will continue watching the material, watching for this channel, monitoring this channel for the content that you may need. You will like it. You will definitely like it, and we will try to make these videos, these presentations, robust as we go along. Thank you once again. All the very best for your AIBE 21, and very soon you'll get the tag of the permissions, all the permissions that you need to practice in courts of India, in the courts of law. We want to see you as successful, popular, and famous advocates. Thank you.